Hi, everyone. Welcome to our Facebook live broadcast. I'm Steve Altishian, Director of Client Partnerships here at Pacific Cascade Legal, and I'm with our founding attorney, Louis Landerholm, to talk about status quo orders, what they are, and when you may want to use them. So, Louis, how you doing today?
Yeah, I'm doing great this morning. How are you, Steve?
I'm doing well. It's not too rainy, so that's always a good thing.
Yeah,
Status quo. So let's kind of start with the basic question. You know, what is a status quo order?
sure. Yeah, and I think there's some misunderstanding around sort of what the purpose is. So I'll kind of start at the beginning. The first part is there's two different types of status quos. There's a status quo that occurs when nothing has been filed in the courts. So it's called a prejudgment status quo. And then there's a status quo option for once you already have a judgment, say you went to court years ago, but things have changed. Then we have what's called a post-judgment status quo in Oregon, and they're two very different things. So essentially, to start with the prejudgment, that's the one that comes up the most. A prejudgment status quo is available for initiating litigants. And essentially, what it does, it's all surrounding the kids, it's all surrounding parenting time. And so, what happens is, parties have been, say they've been separated or they're going to separate, and they've had a de facto agreed upon parenting plan for a certain amount of time. When you go to file a petition, either a divorce with children or a custody petition, when maybe it's not a divorce, then what you can do is you can file a status quo. It's a ex parte appearance. So what that means is just on your own accord, you go in front of the judge and you basically present the document, the declaration that says this is what we have been doing up to this point. What the status quo does is it has a look back period of 90 days. So essentially it says whatever you've been doing in the last 90 days can get locked in and give you an enforceable order right out of the gate so that it's written down, judge signs it. What a status quo can't do is either change what's been going on in the last 90 days or lock in something that just started occurring. It is, what in general has been going on during that 3-month look back.
Are there any specific things in status quos, the prejudgment orders, have in common? Is it just like you have to stay in the same residence, or are there other orders or things that the judge can also order in a status quo, in other than just saying keep the status quo? And what if someone wants to take the kid away or something like that?
Yeah, so it relates to the kids only. It doesn't tell a party what they can and can't do. So, if a party wanted to move out, they could move out. But what it does is it says that, for the kids, this has been the schedule. They go to this school. We've had this agreed upon plan where it's 3 days a week from this time to this time, and it can lock that in. It also is available to say that neither party can leave the state without written permission of the other party or by a court order. So it acts in that capacity as well. If there's a situation where one parent is, saying they're going to leave the state with the kids, it's a mechanism to use to basically get everything to sort of calm down, get an enforceable order, and get the courts involved in the event that somebody tries to do something basically that's not consistent with what's been happening.
So just going to make clear, this isn't about custody. A status quo order doesn't give custody to one of the parents, does it?
Right. And I think it's also, it's helpful to, again, sort of go over what custody versus the parenting schedule is. Custody is decision making. The schedule is the schedule. And status quo can only lock in the schedule, has nothing to do with who's making decisions on medical or school related decisions.
Can you give a few examples of why someone would do this?
Yeah, I think one of the big ones is unilateral changes, like either threatening to withhold. We see it a lot where parties have been operating for a couple of years, 2-3 years, things have been going along well, but something happens and there's a fight or there's, whatever may be a move. And one of the parties says, now I'm going to deviate from what we have been doing because it just works best for me. So right. This is a response to that can basically get filed to say, no, we're going to keep what's in place. The other one that's kind of a sort of normal one, like work schedules change, and somebody has to, go and make a change to the plan, but they do it unilaterally without involving the other parent. It still allows us to, lock that in extreme situations where somebody, threatens to basically flee with the kids, then the status quo can lock in Oregon and lock in the plan that's been in place.
If a status quo is ordered, most temporary orders generally say, oh, this person can't do this. In this case, is the status quo order kind of locked in for both parents? And I guess what I'm trying to ask is a question such like, let's say I get a status quo order and the kids are, have been living with me for, whatever part of the time. And does it also lock me into not making changes? So I can't then take those kids and move them somewhere else? Or is it kind of the traditional, it's just the person who the order is against, or is it really an order that both of them have to obey?
Yeah, it basically relates to both parties in relation to parenting plan. And so what it will do is it will say that this is the schedule. Both parents, because again, it relates to what the kids can do and can't do. So it has everything to do with what is going to happen, in relation to, where the kids are going to be, when they're going to be with mom, when they're going to be with dad, when they're going to be with a parent, right? And so that's it. It definitely is an order that tells both parents what's supposed to happen. The other thing that status quo, what we run into a lot of times is, say parties have been talking about changing a plan. Maybe it was, every other weekend for one parent, but they've been negotiating and having conversations about, changing it to more time to one parent of the other. We can't use the status quo to lock in those potential changes or changes that just occurred, because again, it's that whole 90-day look back of really what has been happening. The goal of the status quo is to get everything to sort of calm down in situations like this, so that the parties just know this is how we're going to deal with kid exchanges and parenting time.
Can the status quo, if it's awarded, be changed during the divorce itself?
Yeah, so there's a couple of components. So, if a status quo, again, this is the pre-judgment status quo, is put in effect, then there's an option for the other parent to request a hearing on the status quo. So you can challenge the status quo, but the only thing that's relevant at the hearing is what was the status quo at the time of filing. That's the only issues that a judge will look at. And so if the other parent doesn't agree that that was the status quo, then it can be challenged. If once the status quo is in effect, if a parent wants to change what the parenting plan looks like, then a temporary hearing would have to be filed with the court. And the temporary hearing basically can relate to more items. It can, deal with support, can deal with payment of secured debts. It can deal with a change in parenting time, it can deal with temporary custody. If it's applicable, most of the time, the custody issue will get pushed to the end of the case for an ultimate determination. But in the interim, there are more things that can be changed, but that takes 3 or 4 months down the road to get in front of a judge. That's why a status quo is so important in a lot of cases, because it does take a while to make a change. So if a status quo had changed, say there had been an agreement of the parties, they had been following it for a week or two, but the status quo is really something else. That's all that can get locked in. If you want to try to get back to what that agreement was, then you need a temporary order, but it takes time to get to that point.
Got it. But you did say that if someone may, say, well, hold it, this person came in with a status quo order, said that for the last 3 months they've been doing this, but that's not really true. So that you can get a hearing if you disagree with that. And if the judge doesn't find that, necessarily it has been a full 3 months, can the judge still do something about that?
Yeah, so under the status quo statute, if the judge determines that there was no status quo, say there are too many changes, there hadn't been a status quo, then the judge has the authority to set a temporary short-term parenting plan. Generally sort of around what the parties have been doing, because a lot of times people are trying to figure it out, and there could be it could be a situation where neither parent has had a set schedule, or people haven't separated, and so this is a new sort of situation, and so the judge does have the authority to set a temporary short-term plan.
Yeah, so you just want to kind of make it clear, this isn't an order where you can decide you're going to have a divorce, move out of the house, move the kids out of the house, and then claim a status quo for your new situation.
Right. Yeah, you wouldn't be able to lock in the recent change. You can only lock in what had been happening before, and that's when we talk to people who are filing, potential clients filing for the first time, we always go over, is a status quo appropriate? Do we want to lock in what had been happening or not? Or do we want to, use a temporary hearing because maybe the status quo isn't what we want, isn't what a client wants, because we don't want to lock that in. We want to, potentially use a temporary hearing or negotiation to determine what the parenting plan is going to look like during the case.
Got it. You said there was another kind of status quo, one that occurs after the judgment.
Right. So once you've already, like if parties have gone to court and they have had a determination for custody and a parenting plan, so there's already a parenting plan in effect. The common, fact pattern is that, parties maybe years ago had a plan that was appropriate for young kids or whatever it was at the time. But upon agreement, which is allowed, you can agree to deviate from your parenting plan. It's just not enforceable. And so what happens is, in those instances, say for the last year, they've been doing week on, week off, but the old plan is an every other weekend plan. one party, for whatever reason, either a move, change in work, or, people just get mad at the other person, then they unilaterally want to revert back to the old parenting plan and revoke sort of this agreement of like the week on, week off. In that instance, you have to file a modification to actually modify the parenting plan or custody, and that's something that we talk to clients about, because it's much more difficult to modify custody than it is to modify unless you have joint. So it's much more difficult to modify the custody determination, much easier to modify the parenting plan. In that instance, you can file a post-judgment status quo. The difference between the pre-judgment and the post-judgment is that the post-judgment status quo does not lock in what has currently been happening. So it basically sets a hearing, generally within 45 days, for a judge to determine what was the status quo at the time of filing. And the reason for the difference is that, parents, you already have a parenting plan. And so, it's less of a concern for the court, for people who already have parenting plans, and there have just been changes to the parenting plan. And so the requirement is there be a hearing for the judge to say, this was the status quo when you filed this. I'm going to lock that in at this point.
Got it. When you filed for the modification?
Correct. Yeah, you have to file a modification to get a post-judgment status quo.
Got it. So that kind of helps the parent who has been relying on, the goodwill and the agreement with the other parent to make these changes, to not just be able to instantly reverse them back before the hearing.
Right.
Got it.
Yeah.
Is there a strategy behind status quos? I mean, is there sometimes where it's strategic to get one? I mean, does it help you later on when a judge makes a final decision?
In a lot of instances, it does. I mean, typically, the most common sort of scenario is, parties have been operating, say, on a week on, week off, or a 50-50 parenting plan. And one parent, wants to change it quickly to reduce time of the other parent. Getting a status quo, and, we'll talk about the timing of it, because timing is really important. Getting a status quo can lock that 50-50 in, so that the parent who wants to maintain 50-50 has a much better position later on down the road, where that is just what is happening, is 50-50. It's a much simpler sort of posture when you end up in front of a judge to say, we have been doing 50-50. And so it's easier to then have a judge just order what has been going on, as opposed to waiting, and then that change has occurred, and maybe there's more questions around, if it reverted back and there was a significant shift in how much time one parent had, then you're sort of fighting against getting back to what you already had. And so there's definitely a lot of importance in those type of scenarios to have a status quo in place, so that you're not feeling like you have to prove why you should get 50-50 anymore. It's very much like, no, we have been doing 50-50. It's just an easier conversation with the judge.
Yeah. Have a final thoughts about status quos that may not have talked about, if you have any, or maybe warnings you would give to someone who wants to fool around with getting a status quo that they really maybe don't yet have the right to get?
Yeah, I think a couple things. So in most instances in family law, there aren't a lot of situations where time and doing things quickly matter. In this instance, timing is very important. There's no definition for when a status quo ends necessarily. There's not a strict, like, after a month, or after a week, or after And so, but there are definitely situations where after a couple weeks of a change, a judge may determine, well, it's not the status quo anymore. I can't lock that in. And so it's really important to act quickly if there's a change that the other parent is trying to impose that you don't agree with. And on the reverse is using a status quo because it is an ex parte appearance. That means that there isn't evidence being taken. The other side is not there. And so abusing the statute to basically lock in something that is new can also backfire on you. And because you want to be the reasonable party when you show up in front of a judge. And so if you're using it to essentially lock in a recent change, that can definitely, negatively impact, that parent down the road in the custody and parenting time case.
Got it. Got it. And just one final question that's kind of popped in my mind. You can't sort of change the status quo status just by taking the kids for a day or two. It sounds like if I get wind you're going to do a status quo and I don't want that, and I take the kids and I leave them at the house and I don't return them for 3 or 4 days, that doesn't necessarily count against the person filing it who had them for the 6 months, the normal one.
Right. Yeah, it wouldn't. Again, you can't change the status quo that quickly. And again, with the reasonableness and withholding is almost never something that a judge wants to see. So that can definitely backfire against the party who tries to use the status quo that way.
Yeah, I totally get that. Wow. Louis, thank you for doing this today. Thanks for talking about status quos, because they are things that people don't quite understand. And I know some, judges who say, people come in, especially without attorneys, and they try to get a status quo after just what we've talked about. They took the kids over the weekend and now want to block in that they get the kids. And so I think talking to attorneys like you are just incredibly important. And so thank you for talking about that today.
Yeah, you're welcome.
Everyone else, thank you for joining us. If anyone has any further questions about this, you can absolutely contact our firm. You connected with Louis or another attorney who can help you.